Did you
far
say
preferable.
Ineffective assistance of counsel is one of them?
Yes, of course. I think we're all taking as given that ineffective assistance of counsel is one, and the Seventh Circuit does say that.
And the sentence exceeding the statutory maximum?
So I want to be careful about how I define that.
But you used categorical rather than statutory, and I want to know what that...
Yes, so what I'm getting at with that is I think what everyone is worried about when they're talking about this sort of statutory maximum thing is the idea like you pleaded guilty to an offense that carries 10 years and you get sentenced to 15. So I'm trying to capture that, but what I'm trying to exclude are things that some courts have said fall within a statutory maximum exception, which are things like whether your restitution was proximately caused by your conduct, whether certain prior offenses qualify as ACCA predicates. Courts have sometimes said that those fall within a statutory maximum exception on the idea that if they're correct about their claim, your sentence exceeds what Congress has lawfully authorized. And we think those types of claims are really what we have bargained to not have to be litigated. We have bargained that the final decision maker on those issues will be the district court.
What about supervised release conditions? So I asked Ms. Black this, but supervised release conditions can be challenged on appeal, notwithstanding an appeal waiver if...
They are categorically unlawful for the statutory offense of conviction, same as the sentence term. So that falls in my second bucket as well.
What is categorically unlawful when you're applying it to supervised release conditions? I mean, I know what it means when you're talking about the statutory sentence.
I think that refers to the type of condition that there's really never any justification for this offense. I mean, like a condition like you can never get pregnant during supervised release.
Is there a term that... Because we have to write an opinion that's going to capture this.
That's why we think categorically unlawful is sort of the best that we can do. We don't want to have to be dealing...
I don't think that captures it.
I mean, the issue is we don't want to have to be dealing with questions like, was this sufficiently justified on the record? Is there enough stuff in the record to support this? Did the judge make enough fact findings? Those are exactly the kind of reasonableness issues that petitioner says are out of bounds, and we don't want you to just be able to call it a due process claim, and then all of a sudden we are doing those reasonableness inquiries when we have bargained not to. And again, I want to be clear, when we're bargaining for this is to the defendant's advantage. I mean, there's a reason that the defense bar does not want to go the route that Justice Jackson proposed of getting rid of all of these altogether, because this is something of great value to the government, and so it is a bargaining chip for the defendants.